Welcome to EPG Pathshala. This paper is the philosophy of law. The module is the history of legal philosophy. The objectives of this module are to sketch some of the philosophical foundations relevant to the contemporary philosophy of law. This module was written by Daniele Santoro from the University of Rome. I'm Akash Singh Rathore, also from the Lewis University of Rome. As we discussed in the first module, legal philosophy primarily focuses on the nature of law, on the fundamental concepts of law. Something that we didn't mention in the first module but gets taken up in the second module is that a crucial aspect of law, philosophically considered, is also the manner by which we distinguish law from other social phenomena. For example, I can tell you now to open your books and study. But is this law? This is an other sort of use of a kind of authority. If you don't recognize my authority, there's no reason, based on my command for you to do so, to open your books and to study. So law has to be distinguished from other sorts of social phenomena, other sorts of command. And what are the ways that we find that can be used to distinguish law? The history of legal philosophy in the modern tradition, or in the tradition that is relevant today, traces its origins back to the ancient Greeks. One way that the idea of law emerged in ancient Greek thinking was through the concept of nomos, and in political phenomena, in the distinction between the Greek word nomos and taxis. Now, nomos is a word, is an ancient Greek word, but we know it through many contemporary forms, like we say nomenclature, or we use the nominative case in grammar. Even the very word name comes from nomos. Nomos, in distinction from taxis, refers to laws or to terms that correspond in some way to something more permanent. But that's not the only way that the word nomos was used in ancient Greek. There was also a distinction between what was called physis and nomos. In other words, physis, from where we get the word physics or physical, refers to the natural laws, and nomos refers to the conventional or human-made laws. So we have this tripartite distinction between physis, or nature, nomos, which is convention in distinction from nature or physis, and nomos as those laws that somehow correspond to nature in distinction to taxis. And the Greek word taxis appears in English in words like taxidermy or taxonomy. In other words, putting things in their place. So taxis refers to those basic sort of administrative rules, economic rules, while nomos refers to, quite simply put, laws. So here we take the first step in distinguishing law from other sorts of social phenomena or physical phenomena. You have natural laws, but those are nothing like man-made laws. In the first module we spoke of gravity, for example. And you have economic laws, and those are nothing like laws or in the legal realm. So this early Greek distinction has proved fundamental in some respects of how we begin to distinguish laws from other social or natural rules, orders, and phenomena. In ancient Greek thought, you had one of the first and most systematic expressions about the nature of the laws in Plato's very late dialogue, The Law. This dialogue is unique for several reasons. First, this is one of the very few dialogues that doesn't have Socrates appearing in it at all. Secondly, as I had mentioned, this is one of the later dialogues. Some people say it was the last that he composed, certainly the longest. And the third most important reason is that it's strangely the least dialogical. In other words, it's most like a treatise. It doesn't have Socrates, It's very late and a mature work of Plato, and it's very monological. So one person speaks throughout. So it's more like a treatise than a traditional Platonic dialogue. For these three reasons, this book on laws was taken as one of the foundations of the theory of law in ancient Greece. Another one of those foundations is, of course, found in the work of Aristotle. Everybody is familiar with Aristotle's Politics, but his real masterpiece on what we can consider the philosophy of law is Aristotle's positivistic account of the Constitution of Athens. That is, Aristotle presents and analyzes philosophically the actual constitution of the city-state or polis called Athens. Now, both the Platonic and the Aristotelian conception of law tied in law as nomos to some other larger order. So it was distinguished from taxes, which I had mentioned were sort of commercial regulations or economic laws. And it was also distinguished from physis, or natural laws, laws according to which nature operates. But nevertheless, the nomos, or the law, was connected to the physis, or the nature of man, human nature. How so? Well, we know that Aristotle defined or described the human being as that animal that engages in discursive practices, or we normally say who is rational. And this was the peculiarly distinctive way in order to understand the nature of law, which was that it was an expression of and bound up with human reason. In that sense, we can distinguish law from something that's arbitrary. I had commanded you in my earlier example to open your books and study. I could also command you to go and jump off of a bridge. This is arbitrary and absurd. It's not in accordance or in conformity with reason and human nature. So what we see in the description or delineation of the nature of law is that it should be in conformity with some other principles that are necessarily implicated by the reason behind law. Now, in the Platonic and Aristotelian sense, it was bound up with nature, human nature, and reason, but there are other traditions which bind it up with something a little more substantive. And the first appearance of that is particularly significant is Thomas Aquinas' treatise on law. Thomas Aquinas' treatise on law occurs within his large theological book called the Summa Theologica. So in this respect, his entire philosophy of law occurs in the context of a broader theological viewpoint. And so the commitment of law to natural human reason is supplemented by or umbrellaed or encompassed in a larger framework, which is God's will, God's command, and the nature of the world, which law must in some way conform to in order for it to be meaningful and valid. In the example that I had suggested, that you should go and jump off of a bridge, obviously this violates some sort of moral precepts, and it violates a kind of natural order, and that's why we would consider that an arbitrary, even immoral command. Now we have the Greek conception linked to nomos with Plato and Aristotle and human reason, and then we have the introduction of the theological, in this case specifically Christian connection with Aquinas, where law takes on its validity or lack thereof in terms of whether it conforms to what the broader theological worldview can accommodate and accept. This ultimately became known as a natural law tradition. Now this natural law tradition is sometimes theological, as it is in Christian thought, in Thomas Aquinas clearly, and it's sometimes grounded in more a Greek rationalist conception. But in both cases, I had mentioned that it is justified in a manner external to itself. So we don't say that law is purely valid as an internal system. Rather, that system points or indicates beyond itself. It can point towards God. It can point towards conforming with somehow the natural order of things, what the Greeks called the cosmos. Or it can conform to what is, in the 20th century, the dominant position, to morality more broadly. So a very recent natural law philosopher of law is John Finnis. And John Finnis completes this sort of tradition that we had seen starting with Plato and Aristotle through Aquinas, of understanding that the nature of law is inherently connected to externalities to the system of law. So law is not self-justifying, but it is justified on the basis of God, the cosmos and the natural order of things, or morality. Well, that's one way of perceiving the law, which has been very important and persuasive in the history of legal thinking, but it's certainly not the only way. There is one dominant rival tradition which is equally subscribed to by philosophers of law, and that's called positivism. So legal positivism asserts something quite the opposite of what these natural law sort of theories have been suggesting. We had seen that the legal system has to be justified by something external to the legal system. Well, positivists say, why should that be? What positivism asserts that there are basically no criteria outside of the legal system, outside of the entire framework of law, that are either in fact supporting the legal system or even needed to support the legal system. To put it in terms of the natural law tradition, the system of law is self-contained and does not need God, does not need morality, or does not need an ordered universe for it to be valid and complete. So these are the two dominant and divergent views that have been argued throughout the history of legal philosophy and continue to be argued in a much more refined manner to this day. So the first real expression of legal positivism that is important is in the writings of the British legal philosopher John Austin. Now, John Austin was, interestingly, a student of the utilitarian philosopher Jeremy Bentham. And Austin had proposed, in some way, the very first statement, clear statement, crisp and concrete statement about law that made one understand that the nature of the legal system was entirely self-referential and closed. According to the definition of law by John Austin, every law is a command issued by a sovereign, backed by a sanction, to which people have a habit of obedience. And this is a very beautiful and elegant assertion about the nature of the law. Law is a command. That command is issued by the sovereign. That sovereign enforces his command by the threat of a sanction, punishment, and to which people have a habit of obedience. Now, take this as a self-enclosed definition of law. Do you need morality? There's no mention of morality. There's a mention of a command, a sovereign, a sanction, and obedience. Do you need God? Do you need an ordered universe? You need nothing external to the system of law. So this is the positivist fundamental definition offered by Austin gives us an entirely free-floating conception of legal systems. And this is the most important break from any kind of natural law tradition, because whether it was God, whether it was human reason in conformity with human nature, whether it was morality, in each case, the legal system is not free-floating, but is sustained through something external to it. But here, the legal system consists of these four moments: the command moment, the sovereignty, the sanction, and the obedience, which help to explain the legal system in its nature and its entirety. Now let's go back once again to the example I had given you. I command you to open the book and study. Now, let's see how that functions. It is a command. All right, that's fine. Is it a law? Is it a command issued by a sovereign? Well, perhaps I'm your professor, so I have a certain amount of authority over you. Is it a command issued by a sovereign with backed by sanction? What am I going to do to you if you don't open the book to study? Well, here we start to come to a cloudy situation. There's nothing really that I can do to you. But let's assume you were in my class and I was the one who was going to grade you. So I could sanction you by reducing your marks in the class. And then finally, to which people have a habit of obedience. Well, this is a one-to-one thing, right? I've told you to open your book and read. So what does it have to do with the people? So we've seen two ways in which the command that, for example, a professor might make to a student has an analogous authoritative element that's like law, but it fundamentally fails in two respects. This is a person-to-person situation, whereas law relates a sovereign to a people who have a habit of obedience, and the sanction is a little bit fuzzy here because we could stretch the metaphor and say you were right here in my class, and therefore I could punish you by giving you a bad grade, and then we could say there are many other students in the class whom I could also punish. If that were the case, then yes, indeed, we have a miniature legal system. We have a system where the professor is the sovereign, the student is part of a community of people who have a habit of obedience to the command of the sovereign, which is backed by a threat of punishment. So what we've seen here is just the way that, for example, a classroom professorial organized university situation replicates the nature of a legal system. But the important point is that this is a community that is very closed. And when we talk about a people, generally we refer to a legal community that is larger. But within positivism, and you should note this, that professorial experience, when you've submitted yourself to the rules of the university and agreed on the authority of the professor, is precisely analogous to a legal system. It is a micro-legal system. It's simply not a state legal system. Okay, now we have some clarity on the positivist suggestion of what the nature of law is, and it comes down to a certain sort of simplification if it's precisely analogous to any set of rules to which you grant authority and subject yourself to the sanction and have a tendency to adhere to, and you do not need to appeal to another group of reasons for why you grant that authority. In other words, you don't listen to the professor because it's the morally right thing to do. Rather, strictly in terms of the framework, you listen to the professor because of the threat of sanction. Now, the same thing happens in the nature of law. The problem is, when we look at all of the laws, is it really the case that every law is a command with a sanction? Well, about 100 years after Austin presented his fundamental definition of law, the British Oxford philosopher of law, H.L.A. Hart, realized that there was a certain inadequacy here. In other words, this definition would account for the legal system as a whole, but it couldn't account for every single law produced. After all, not every law is a command issued by a sovereign backed by sanction that is to which a people are obedient. These you can call primary rules. So primary rules might satisfy this condition, but there are several other kinds of laws that don't fall into that category. So hard to distinguish primary rules and secondary rules. Primary rules are the ones that we can call Austinian sorts of law. They confer powers upon people. For example, the Constitution confers the powers that the Parliament will have, that the President will have, that the Prime Minister will have, that the Supreme Court will have, and so on. And these are rules, fundamentally, primarily the rules. But there are also another whole strata of secondary rules that regulate relations between people, that help you identify whether a primary rule is indeed a primary rule or not, and all kinds of other administrative regulations. And you can think of fire code, and even if you're on an airplane, you're told that tampering with the smoke detector violates a law, and you're told that if your window blind is down, that it violates a law, and so on. So these are all kinds of laws that are not really in conformity with that grand sense of law that Austin had identified. So Hart did legal positivism a service by distinguishing the primary rules and the secondary rules. The important part is, of course, that the secondary rules must rely not on morality, not on God, not on anything external to the legal system, but on the primary rules in order to have their validity. Now, one further aspect within HLA Hart's philosophy of law that he introduced was a rule of recognition. In other words, it was something that falls outside of the laws itself, but that is a condition by which the laws are seen to be laws. This rule of recognition, you can put in more simple language, is a kind of rule of legitimacy. John Austin had that fourth component within his definition of law, which was obedience. And Hart takes that fourth component and he turns it into this recognition. Now, we had tried to suggest that a system of law, at least in positivism, is completely internal. If it's completely internal, that means that it's not externally justified. Now, if you don't justify something with reference to something else, you justify it with reference to itself, this seems a bit circular. So what is the condition that we can use to verify whether a legal system is justified, or as I had said, legitimate? Obedience is the answer that Hart gives. So a legal system, let's say, is justifiable because it conforms to natural human reason, it conforms to God's will, it conforms to the master plan of the universe. It can be all of those things in various sorts of theories that don't see law as free-floating. But if you see law as free-floating, how do you justify the legal system? And the answer is in this idea of obedience. When most of the people, most of the time, follow the law, you have justified that system of law from within and not from without. After HLA Hart, who was an Oxford jurist, the most important legal philosopher of the 20th century proposed a system that was referred to as legal formalism. Now, formalism is very much the same thing as positivism. Positivism is a tradition as articulated in Anglo-American system, and in continental system it was referred to as formalism. Hans Kelsen, the Austrian legal philosopher, proposed a theory of law, which he referred to as a pure theory of law, that was very similar in some decisive respects to HLA Hart's legal positivism. What he had done was he had, building on Austin's work, but primarily wanting to clarify Austin's work in a post-Kantian environment, where in continental Europe Kant's critical thought proved to be decisive and sort of the benchmark of whether any work in the humanities and social sciences was worthwhile. Kelsen wanted to ensure that Austin's work was adequate to a post-Kantian milieu. So the theory of law, according to Kelsen, postulated that there is what's called a basic norm. And this basic norm is the fountain or the spring from which all legal validity arises. So any law, in order to be valid, has to find its source, its genealogy, in this basic norm. The basic norm is authoritative, again, in a freestanding manner. The basic norm is not authoritative because it's a moral norm or because it's sanctioned by God or anything like this. It is just a basic norm posited as such. You can think of it somewhat in terms of an axiom in Euclidean geometry. So the shortest distance between two points is a straight line, is axiomatic in Euclidean plane geometry. Someone can say, why? Is it because is it morally justified? Is it theologically justified? And the geometer answers, no, it's just an axiom. It's something that is basic, and once you accept it, everything follows. And that's the nature of the basic norm in Kelsen's thought. So it is a formal system of legal philosophy that doesn't depend on the content. It just depends on whether every law follows like a geometrical proposition from the basic axiom, which is the what's called the Grundnorm in German, the basic grounding norm. As we've been discussing, in legal positivism, what is fundamentally at stake is that the legal system should be free-floating. Now, the examples that I had given of what could ground or justify the legal system were theological, but also primarily moral. And while in the early history of the philosophy of law, the real struggle was about whether human law conforms to divine law and divine will. In the latter part of the philosophy of law, which is up to this day, the real struggle or contention is between morality and law. What is the nature of the relationship between morality and law? Now, positivists continue to assert that law is free-floating, it has no external sources of justification, and morality is precisely such an external justification. That means that law is a pure system that has no need for morality to justify it. This position in legal positivism is called an exclusivist kind of positivism. That means that the legal framework is exclusively valid. It excludes any sort of moral input. Morality is something that is completely irrelevant to the validity and operation of law and is not required in the justification of law. Well, there's a little more inclusive type of legal positivism, which is called inclusivist positivism, which suggests that moral considerations, in fact, do play some role. They do filter into the legal framework in some way. But nevertheless, you have to realize that the legal system is still free-floating because it doesn't rely on morality for its justification. It doesn't rely on morality for the legitimacy of the system itself. Now, this argument between the exclusivist and the inclusivists, legal positivism, has taken on more or less the whole field of the debate between the natural law tradition and the legal positivism tradition. So it used to be, before Austin, a fight between divine orders and the human order. This has transformed slowly into the contemporary debate between inclusive and exclusive positivism. Two of the greatest legal philosophers of our time, Ronald Dworkin and Joseph Ratz, represent in some respects these two positions. Dworkin has never really identified himself with the natural law tradition. He is much more positivistic, but his positivism is deeply inclusive, whereas Joseph Ratz has maintained very dogmatically, very consistently over the last 30 years that kind of Austinian positivism, where nothing else is required outside of those moments of command, sovereignty, punishment, and obedience. This is all that we need. Morality has no scope, it has no relevance, it's completely external to the nature of law. So a great deal of the last 20 or 30 years in the philosophy of law has been different kinds of argumentation and dialogue between Dworkin and Ratz on the nature of the relationship of law and morality. Ronald Dworkin defends a conception of law where, while the nature of law, let's say, created by legislators, may be purely positivistic and free of moral content, the practice of law, the fact that law is a living system and not just etched, carved into stone and not permutating over time. The practice of law is deeply implicated in morality and moral conceptions. And he refers to fundamental rights, for example, human rights that are incorporated into every constitution as a Bill of Rights or freedoms, fundamental freedoms, as evidence of this presence of moral considerations in legal systems. So how do you justify, for example, that human life is fundamentally inviolable? How do you make a claim like that? You know, we can make the Kelsen sort of axiomatic claim that it's just an axiom internal to itself. Dworkin argues, not at all. It's a basic principle of moral philosophy that is inserted into the legal framework, because the legal framework always has elements of moral thought inserted into it. Now, once again, just to be clear, he's not suggesting that the legal framework gets its validity by that moral system. The legal framework is self-standing, and nevertheless, the moral framework is very much a part of the legal framework. So what Dworkin argued was, if you look at any constitution or any legal system, it doesn't need external justifications to function, but as it functions, it automatically assumes all sorts of elements from the society at large. And one of the most important elements is morality, of course. So when judges judge, when people try to decide between conflicting laws, how do you decide? Dworkin tells us that in all of those cases, the legal system, though free-floating, might have no solution. So there are analogies in the philosophy of mathematics, there are analogies in the natural sciences about whether the problem that the system poses can be solved by the system itself. In law, Dworkin says, sometimes law poses problems that cannot be solved by law. He refers to these as hard cases. A hard case, for example, is something for which legal reasoning, taken in and of itself, simply cannot decide between two options. So just imagine that a Supreme Court, for example, a bench of 15 people or 9 people or whatever, wishes to decide a case, and there's as good legal reasons on one side as there are on the other side. Dworkin's suggestion is, in such a hard case, what really tips the balance is not the legal reasoning, but the input of some sort of moral reflection. Hard cases are cases where a fundamental dilemma from the nature of the system can't be solved by the resources internal to the system, and so something else has to be pulled from outside, and that, Dworkin says, is moral philosophy. Now, Dworkin's argument then is inclusive, because though positivistic, he shows that in the nature of the structure of law, for example, in the Constitution you have fundamental rights, which are a moral element, and in the practice of law, adjudication, deciding between cases, in all of these moments of legal life, morality creeps in. So Joseph Ratz defends an exclusivist version of positivism. This is a very hard line kind of positivism, like you found in Austin, in that first real clear articulation of the nature of the law. Now, once again, to repeat Austin's formulation, the law is a command issued by a sovereign with a threat of sanction to which most people are obedient. In that sovereignty and obedience, what you see is authority. Now, if someone were to ask within the Austinian conception, why do you follow the law? You don't need to give a Socratic answer. You don't need to give a fundamentally philosophical answer, tying the practice of following the law into some larger cosmic order. All you need to do to give a perfectly acceptable answer is to say, because the sovereign commanded it, and it is backed by sanction. So, in other words, in order to answer the question, why should I follow the law, you don't need to tie it in to your theological worldview, you don't need to tie it in to your beliefs about a complete human good, your ethical philosophy, and so on. It is adequate, because of the nature of the legal system, to say, I must follow the law because the sovereign has commanded it. Everything that's already packed into the authority of the sovereign justifies your answer. Now, what Ratz says is that this statement of Austin, irrespective of what Dworkin says, is fundamentally correct. When you decide a hard case, you don't have to bring in morality. What you have to bring in are those constituent elements of obedience, authority, and command. Now, there is an underlying set of issues that you need to realize, which is, how do you know what is the command? It should be publicized. But what if you have a command both to do and to not do the very same thing? So Ratz says that hard cases are not actually cases that can't be solved internally to the legal system. Rather, they are cases where the legal system has internal inconsistency. And these are very two different explanations for the same phenomenon. So what Ratz says is that the legal system must be in a continual process of becoming more and more rational, which is to say, less and less internally contradictory. And that clarifying of contradictions, or resolving these contradictions, will ultimately resolve more and more hard cases and turn hard cases into easy cases. So his suggestion is that we get more and more hard cases the more and more we try to justify the legal system by externalities to the legal system. Now let me give you an example. Let's say the speed limit is 80 kilometers per hour. I can be asked, why do I follow the speed limit? And my answer can be, because if I go more than 80 kilometers an hour, I might cause an accident. But that is not obedience to authority. That is finding the rationale behind why the authority has issued the law. And just as I had mentioned before, in Austin's view, it's completely acceptable to say, because the sovereign said so. In Ratz's view, not only is it acceptable, but it's imperative for the law to function properly, coherently, and without contradictions, for us to answer like this, because it's the law. If I try to give second-order justifications of the first-order norm or the law, then what I'm doing is I'm undermining the authority of the sovereign, right? I'm attempting to find out what the sovereign must have been thinking and why he must have said what he said. And all of these things complicate our relationship to the law, they complicate the legal system, and they introduce externalities into the heart of law, and in the process they confuse law and they make easy cases hard. So Ratz's idea is very compelling. I mean, he has quite a good argument. If it were the case that the authority alone were the governing reason behind which we justify law, then we will not be introducing all the other elements which lead us into confusion about whether we should or shouldn't follow the law, whether the law applies to us in this case or it doesn't. For example, if you roll up to a red light at 3 a.m. and you look around and you think, you know, this red light was put here because there's normally a lot of traffic, and normally if I go on a red light, I'll cause an accident and so on. But none of those things are relevant in this case. It's 3 a.m., there are no more cars. Therefore, I free myself from the authority of the law because of the rationality that must have been there behind the law, and I drive. Now, this is making yourself an exception in a way that Ratz says basically doesn't put you in conformity to the arguments behind lawmaking, it just makes you a criminal. So in this sense, Ratz reproposes the Austinian proposition about what law is, and attempts to solve the problems that Dworkin has introduced by saying you're making things difficult for yourself by introducing elements that we didn't need to introduce in the first place. Now, the greatest problem with this position is, of course, the very historical events of the 20th century that put the positivism of Austin into a bad light in the first place. So, obedience to authority in the Nazi regime in Germany was the number one cause for the slaughter of millions of people in a most criminally heinous way. For pure positivists, what makes the law of Nazi Germany, I mean, on what grounds can you judge it? If you're a pure Austinian positivist, then the legal framework is free-floating. It needs nothing else other than Hitler, that's the sovereign, and his sanction, and the fact that most Germans were obedient. It needs nothing else for it to be law. Now, the intriguing thing, I don't want to make light of this because Josef Ratz is actually an Israeli Jew. The intriguing thing is that most people have used this phenomenon of the Nazi death camps and the unjust, what we know to be unjust laws of that regime, as a disproof of the Austinian position, and say, no, law is basically freestanding in its operation, but it must be grounded in some higher conception, because if it can lead to the creation of death camps, then we know something has gone wrong. Ratz has to repropose a much more sophisticated account for judging or condemning a legal system than is available in the resources of Austinian thinking. Now, in conclusion, legal philosophy, as we've been discussing it, is a very distinctive discipline at the crossroads of legal reasoning, legal framework, and law, and philosophy, political philosophy, and moral philosophy. The philosophy of law, then, is a kind of crossing or intersection between the legal framework and moral and political philosophy. Its main function or its main purpose is to explore the law in the light of these philosophical questions and philosophical riddles that face us. What this module has attempted to do is to hone in on one of the most salient riddles or conundrums or debates within the history of the philosophy of law, which is that between natural law traditions and legal positivism. Obviously, in honing in on these kinds of debates from Austin to Ratz, we've left out numerous other sorts of debates and other sorts of positions in the philosophy of law, like legal realism or pragmatism, sociological theories of law, economic theory of law, critical legal studies, and so on. But the modules that follow in the first part of the philosophy of law paper will each take up these other aspects of the philosophy of law, so you get a quite comprehensive picture of the philosophy of law before moving on to its incarnation, specifically in India. Thank you.